Weiss+Associates presents The Birth and Death of the Internal Revenue Code. Weiss+Associates has ventured into the depths of the cavernous Internal Revenue Code to expose the jurisdictional differences between the constitutional republic and the statutory United States, meaning the District of Columbia. The national government has created massive fraud and misdirection in its effort to target and convert sovereign American nationals with propaganda in order to capture massive annual amounts of their hard-earned income. As you've learned by watching our other videos, the United States Supreme Court has declared in the Pollock decision that the federal income tax was 1. A direct tax, and 2. Could only be levied upon sovereign American nationals with the inclusion of Article 1, Sections 2 and 9 of the Constitution's Rule of Apportionment requirement. When you read the actual wording of the 16th Amendment, you see the willful and intentional omission of the Rule of Apportionment requirement. Any attempt to bypass this Rule of Apportionment requirement of the U.S. Constitution amounts to targeting those in the constitutional republic, and the Supreme Court stated such action to be unconstitutional. So, as you continue viewing, understand that the federal income tax discussion herein refers to a tax only authorized or levied within the federal United States and not within the constitutional United States. For more on this, please review our YouTube video on the duality of meaning in the term United States. For any federal law, there's the legislative intent of that law, as well as the enactment date of that law in the form of an implementing regulation. Reviewing the implementing regulation for the Internal Revenue Code of 1954, one finds the effective date of enactment to be stated in 26 CFR 1.0-1 to be August 16, 1954. Here's what's stated in regard to the enactment date. The Internal Revenue Code of 1954, which became law upon enactment of Public Law 591, 83rd Congress, approved August 16, 1954. This implementing regulation goes on to discuss several aspects related to the citation regarding the heading Internal Revenue Title, which may be cited as the Internal Revenue Code of 1954, publication in the United States Statute at Large, and cross-reference. Where it becomes extremely interesting is in subsection D, pertaining to enactment of Internal Revenue Title into law. You'll find clearly stated, the Internal Revenue Title referred to in subsection A1, meaning the Internal Revenue Code of 1954, is as follows. In general, the provisions of the Internal Revenue Code of 1954 are applicable with respect to taxable years beginning after December 31, 1953, and ending after August 16, 1954. This expression may be difficult to comprehend on an initial reading, so it might be helpful to review it once more in a simplified statement. Basically, this implementing regulation shows that the Internal Revenue Code of 1954, the operational Title 26 that the IRS uses today, was enacted into law on August 16, 1954. However, according to the same implementing regulation, it stated that the provisions of the Internal Revenue Code of 1954, which includes the IRC of 1986 in use today, ended or died on the very same day, August 16, 1954. This means that the implementing regulation, 26 CFR 1.0-1, began and ended on the very same day. The IRC of 1954 lasted probably no longer than 44 nanoseconds, but certainly no longer than August 16, 1954. The impact of this statement is profound. In subsection B, Scope of Regulations, you'll find stated in part, the regulations in this part deal with 1. The income taxes imposed under Subtitle A of the Internal Revenue Code of 1954, and 2. Certain administrative provisions contained in Subtitle F of such code relating to such taxes. Subtitle F pertains to the enforcement procedures used by the IRS, such as substitute for return, assessment, deficiency, and lien and levy actions against those who are legal U.S. taxpayers. So, one sees that the income taxes imposed under Subtitle A of the IRC of 1954 and the enforcement under Subtitle F are directly linked to the birth and termination of the IRC of 1954. Looking closely at the statutes related to the IRC of 1954 and its enactment, you find stated in 26 U.S.C. Section 7851A1A that Chapters 1, 2, 4, and 6 of this title shall apply only with respect to taxable years beginning after December 31st, 1953, and ending after the date of enactment of this title and with respect to such taxable years. The uniqueness of this narrative is obvious, and even more so when reading 26 U.S.C. Section 7851 A6A Subtitle F, where it states in part, "The provisions of Subtitle F shall take effect on the day after the date of enactment of this title, and shall be applicable with respect to any tax imposed by this title." The day after the date of enactment would have been August 17, 1954. However, the IRC Subtitle A and the implementing regulation at 26 CFR 1.0-1 show that the IRC of 1954 began and ended on August 16th. Upon the day after the date of enactment, August 17th, there were no statutes for Subtitle F to actually enforce, as Subtitle A of the IRC of 1954 died the day before. Thus, all the withholding, assessment, deficiency, and lien and levy procedures used by the IRS against American nationals who only work in the private sector cannot be subjected to the IRC of 1954 that no longer exists. So, why would the government enact legislation that ended the same day it was passed? Well, it needed some law to point to in order to justify their intrusion into people's lives, knowing full well those people would not even bother to read the actual wording of the law. Yet, it ended the entire scheme the same day so that it would never be accused of violation of the Supreme Court decision in the Pollock case, or violate the 13th Amendment, which outlaws slavery and involuntary indentured servitude within the constitutional republic. Remember, the federal income tax was initiated basically to be a tax upon the national government itself, its employees, and those who live in U.S. territories. However, it needed an implementing regulation to present via propaganda its effort to extend this municipal income tax directly into the constitutional republic, while at the same time hiding the truth in plain sight. This bit of chicanery was the tool used. In 26 CFR 1.871-1A, you'll find that the municipal federal income tax applies towards statutory U.S. citizens and U.S. resident aliens. When you read this section, you'll see that the voluntary election espoused by the U.S. Congress includes converting American nationals into U.S. resident aliens in order to be legally taxed. Quite a unique ploy. American nationals are lawful non-taxpayers of the federal income tax imposed only upon those statutory U.S. citizens identified in 3C Amjur 2D, Section 2689, as those who were born in territory over which the United States is sovereign. Remember, states like Texas and Michigan are not territories and are not under the exclusive jurisdiction of the U.S. Congress. This expression of U.S. citizen is clearly different from and doesn't include any American national born in the constitutional republic or naturalized therein. This is why the federal appellate court in Long v. Rasmussen stated in part, "The revenue laws are a code or system and regulation of tax assessment and collection. They relate to taxpayers and not to non-taxpayers. The latter are without their scope. No procedure is prescribed for non-taxpayers, and no attempt is made to annul any of their rights and remedies in due course of law. With them, Congress does not assume to deal, and they are neither of the subject nor of the object of the revenue laws." In review, the federal income tax has never been lawfully imposed against any American national working in the private sector for the following reasons. 1. The United States Supreme Court Pollock decision in 1895, per the lack of inclusion of the rule of apportionment as required in Article 1, Sections 2 and 9. 2. The legislative intent of the 16th Amendment, created by President William H. Taft in 1909 and promulgated in the Congressional Record of the U.S. Senate, which states that the federal income tax was to only be levied upon the national government. This means those who work for that government and those who are subject to the dominion and control of that government, or those who elect to derive income from the use of federal property per 26 U.S.C. Section 861. 3. The U.S. Department of the Treasury, stating in 31 U.S.C. Section 321 D1 and D2 that the federal income tax is a gift or bequest and not a mandatory obligation imposed upon American nationals. 4. The decision of the Federal Appellate Court cited in 1922, Long v. Rasmussen, clearly stating that American nationals, non-taxpayers, are neither of the subject nor the object of the revenue laws. 5. The wording used in the enactment of the IRC of 1954, if the law were to apply to American nationals, which it clearly doesn't. And 6. The national government cannot violate the 13th Amendment by compelling American nationals to associate with the national government in order for them to be subject to a tax never imposed by law within the constitutional republic. It's important to keep in mind that the federal income tax is law within the federal United States, meaning the District of Columbia and its U.S. territories. There's no issue on the application of statutory laws within the territorial jurisdiction of the national government. Jurisdiction remains a cornerstone in understanding the two different jurisdictions that are each referred to as the United States. Words are critical here, and thus, so are the definitions to properly understand their meaning. The mind conditioning is so well entrenched that it takes a lot of effort to make a coherent presentation to private sector employers and to change the mind of the vast majority of American nationals who've been purposely led astray over the years to believe the flat earth mentality surrounding the federal income tax. Fear can be overcome with knowledge, and it can prevent American nationals from being destroyed financially for a debt they never owed. Our revocation of election process can provide you with the exit door to the U.S. tax club for American nationals working in the private sector who inadvertently made an election years ago by filing their first Form 1040 income tax return. This revocation provides a lifetime benefit provided by the U.S. Congress, and for good reason. They know the deception that was put on the American people by its propaganda over many decades. Now is the time to act so that you can start funding your retirement years and be worry-free from dealing with the federal income tax. Be proactive and retain your income from your private sector employment. We hope that this information has provided some new insights, and we look forward to hearing from you soon. Please subscribe to our channel and smash the like button. If you have any questions, please email us at bilateral@gmx.com. We have more videos, the links to which are located in the resource center of our website, Weiss+Paris.com. Thanks for watching.